Well, let's kick off. Welcome to today's webinar. We'll be talking about legal essentials for marketing your business online. I'm Alex. I am the co-founder of Sprintlaw. Just before we get into the legal content for today, a quick introduction to those who don't know who we are. We're an online law firm made for startups and small businesses. Unlike your traditional lawyers that charge by the hour, we do everything fixed fee with transparent pricing. We have experts in all the different areas of law that smaller businesses may need help with, from setting up your company, drafting contracts, protecting intellectual property, employment law, capital raising, privacy, and as we'll be discussing today, help with digital marketing related legals. And we have a membership. It's optional, but about 90% of our customers sign up to it. It's great value, gives you access to unlimited calls with our lawyers, a bunch of other great features. You can build your own free legal documents, use it as a DocuSign style e-signatures tool. There's credits to use on legal services, and we've recently launched a bunch of AI tools, including an AI audio lawyer that you can actually chat to on the platform and ask advice. So if you're not already a member, you may want to consider signing up. A bit more about us: a bit over 7,000 clients, lots of happy customers, a team of over 50. We're based in Australia. We've also expanded to the UK and New Zealand in the last few years and won many industry awards that we're very proud of. If anyone has questions flowing from today's presentation, you can book in a free chat with our team. I think we'll drop the link in the chat as well. Or if you've got your phones handy, you can scan the QR code. I'll show this again at the end. And again, any topics from today you want further information on, or any other areas of law you need help with, do feel free to reach out. So today we're going to be talking about a ton of different areas of law that relate to marketing and digital marketing. We'll begin with a bit of an overview of how law intersects with marketing in general. We'll then look at some of the key laws to be aware of when you're doing marketing or advertising. We'll look at social media, influencer marketing. We'll talk a bit about privacy, spam laws for email marketing, and if we get time, we'll talk about IP and competitions, running competitions on social media, online or otherwise. As I'm going through, do feel free to drop questions in the chat. I don't mind taking questions while we're on the topic. It can help flesh out whatever I'm talking about, and so I'll keep an eye on that and try and answer as many questions as I can. So let's just begin by talking a little philosophically about how to think about the law as it relates to marketing. And for those that have been to some previous webinars, I've covered some of this before, although it's a little different when we're thinking about the law and marketing and how it fits together. And a lot of questions we get from marketers or people doing marketing is, I want to do this thing, write this blog post, promote my product in the XYZ way, and they're asking, lawyers, is this legal? That's kind of the question that we get, which is an understandable way to ask the question, but it's important to understand that when we're thinking about law in a business and particularly marketing context, there's a couple of different types of laws that are relevant, and it's worth being aware of how to think about those things. I mean, we have in the top left corner of the slide these things called laws and regulations. So there are actual pieces of law passed by Parliament or by government bodies that say you can and can't do X, Y, Z. You must wear a seatbelt when you're driving a car. You can't go over the speed limit. You can't behave in certain ways in public, et cetera, et cetera. If you break those laws, you're breaking the law. You can be fined. You can be penalized. There can be penalties. And in a similar fashion, there's laws in relation to marketing. You can show certain types of content in your marketing. You can't engage in false advertising. You must not commit fraud. So there are laws that if you break them, you're breaking a law of the government, and there can be penalties and fines and potentially more serious consequences associated with it. But there's also what we call private arrangements. For example, when you're signing up to a social media platform like LinkedIn or Facebook or Instagram or whatever it is, there are terms and conditions or contracts you're agreeing to. Now, if you break the terms of those contracts, you're not breaking the law per se. It's not like the government is going to come after you for breaking the terms of Instagram's terms and conditions, but you could potentially be liable for some losses or penalties from the platform. You could be kicked off the platform, or you know, have some impact happen as specified in the terms and conditions. So I think it's important to distinguish between the two, and then finally, it's important to understand that, and we'll talk about this a lot in today's presentation. A lot of the laws, whether they're laws of government or you know, the laws of the terms and conditions, if you will, that are privately specified by the organizations, they're very open to interpretation, and this is why lawyers exist often to appear in court or to argue, you know, how things should or should not apply. And so often we find ourselves answering questions in a marketing context of rather than yes or no, we talk about risk, high risk or low risk, and it can be difficult to know whether a particular activity that you want to do in a marketing context is going to break the law or not break the law, going to breach the terms and conditions or not breach the terms and conditions. And so what you want to be thinking about is the thing I'm doing a high risk activity? And you know, if I'm breaking this particular law, what are the consequences? Or if I'm breaching this particular contract, what are the consequences? Is the risk very high as well? And so, you know, we've got this classic risk, likelihood of risk register. If it's a big risk that's likely to come to fruition, if you do it, you should absolutely be very careful. If there's a low risk, maybe there's a theoretical risk you might be breaching this law, but it's very difficult to interpret whether you would or wouldn't, and you know, it's a low risk campaign and the penalties, you know, not very big anyway, then you might take the risk and kind of go for it, if that makes sense. So this is how a marketer may want to think about you know, different marketing activities. You'll be hard pressed to find a lawyer that will advise you to do anything other than in the green section on this kind of chart. We are all about being risk averse, but it's very difficult to get to zero risk. And so I think it's worth thinking about the questions you might have in this area, I guess, through this lens. So let's now talk about some actual law stuff. So just want to begin by talking a little bit about the laws we have in Australia around advertising. In Australia, we have something called the Australian Consumer Laws, which people may have heard of, and they are a very comprehensive set of laws that apply to any businesses that are marketing to consumers. Now, consumers doesn't just mean individuals, as the name suggests. It can also apply to small businesses. They can be considered consumers for the purposes of the Australian Consumer Law. So if you are a B2C or B to small b business, you have to comply with these consumer laws. Even if you only work with large businesses, there are still some similar laws, particularly around misleading conduct, which we'll talk about in a second. So you're not off the hook, but really a very large majority of businesses do have to think about these Australian consumer laws. And you know, globally, we have one of the most comprehensive and strong kind of consumer protection regimes, and so this affects the way that we have to think about advertising here. So there is this broad statement in these laws, the Competition and Consumer Act, which basically says it's illegal for businesses to engage in conduct that misleads or deceives or is likely to mislead or deceive consumers or other businesses. And there's many different examples of what could be misleading. False reviews, comparison tables that you might set out on your website, your product descriptions. And this is one of the central challenges in marketing your business, because you want to promote it, you want to talk about how what you have, your product or service, is the most amazing thing that solves this amazing problem for consumers that will give them all these amazing benefits, and you want to puff up the content and make your organization look good, and convince people to try the product or service, but you have to be careful that it doesn't go so far as to mislead or deceive. Now, what is the definition of misleading or deception? You know, we're right into the territory I was talking about earlier. It has a somewhat subjective meaning, and the only way we can interpret this in practice is to kind of look at some examples. So I'll give you some examples which you know, were found to be misleading and deceptive. So we have here a case between Nurofen and Panadol from 2018, and you can see they've got this ad they ran on social media and I think in print as well. Nurofen is better than paracetamol. Now, they didn't use Panadol's brand name, probably for trademark purposes, we'll talk about later, but but obviously Panadol, as the leading salespeople of paracetamol, were not very happy with this, and they've got this chart that looks reasonably scientific. And someone reading this would think, well, if I want to get rid of my headache quickly, I think I'm going to go with Nurofen, because look at that, the chart is saying that it's a lot quicker. Um, so this ad suggested that Nurofen's quicker and more effective, and it also implied by using a chart that the claims were backed by scientific research. And so, of course, if they're going to make this claim, they better have good science. But it was found that some of the research they relied on was, Nurofen-sponsored research. There wasn't a clear scientific consensus that this chart was true, and they suffered a really big fine of $6 million as a result of running this ad campaign. So, if you're making these scientific claims, you have to be careful. And again, you can see in this case, even though they had some evidence, it wasn't backed by strong enough scientific research that the layperson would have, sort of looking at this, considered, that may have been justifying it from just looking at it. So I think that's a fairly kind of black and white example. But there's other cases which are a little more subjective. So in 2002 we got the case of Duracell and Eveready, and Gillette was comparing its Duracell battery with Energizer's super heavy duty battery, and basically saying our battery lasts up to 3 times longer. Now it was debatable because they said up to 3 times longer, and again, you can imagine a similar debate around what tests were conducted, what's the science behind this, is this actually 3 times longer? But in this case, because of the wording that was used, because there was reasonable evidence behind this claim, and because it was quite specific with the products that it was comparing, the court was satisfied. Right, so it's almost quite a similar case, but just the underlying facts were different. They could back up their claim. It was actually found to not be that misleading. Similarly, with Optus and Telstra, they did one of those plan comparisons that many of our software company clients do, where they have our plan, our competitor's plan, and they listed the differences in features. Now, there have been cases where those comparison tables have not been found to be okay. Where people selectively choose a collection of competitors' features to make their competitors look really bad, and then they've got ticks for every feature, and they say their product's better in every way. So this isn't to suggest that you can't be misleading with comparison tables, but certainly in this particular ad, it was debated. Telstra made that argument. Optus had, I think, quite fairly compared the differences, and in fact showed a couple of features where Telstra had benefits over Optus, and in the end, it was found to be okay. But then Optus wasn't so lucky. In 2015, they claimed their broadband service had NBN-like speeds, and that was not supported by fact. So you can see here there's kind of like an element of rigor and specificity being used in the Duracell and Optus and Telstra case, where we've got specific comparisons between specific plans that really try and be embedded in fact, are justifiable by fact, and in doing so are less likely to be perceived as misleading, because they can make these reasonable claims, whereas these kind of what you might argue lazier comparisons, we have NBN-like speeds, without actually explaining what that means, is the kind of stuff where you're falling into that misleading territory, or these charts, I think, are quite explicit. So something to think about when you're promoting your product. Again, it's never going to be black and white. I'm never going to be able to look at your ad and say it's definitely fine. It's just a low risk, high risk thing. But you want to keep this in mind when you're designing promotional content or ads for your product or service. Is what I'm presenting just as what we call, as lawyers, mere puff, which is we're using persuasive language to help people be convinced to try our product or service, or does it go into this territory of actually providing potential falsehoods that mean that they're buying it, not really understanding the truth behind the product or service? So a couple of comments we've had so far. One was just on the consumer laws. If my customer is a large business, such as a utility or government-owned entity, does Australian consumer law apply to them? If your customer is a large business, it is very possible the Australian consumer law does not apply. The fact that they're government owned or not at a shareholding level, I don't think affects the consumer law in and of itself, but there's some tests which I think it's either $10,000 or $20,000 purchases. If the transaction value is above those volumes, and I think actually the thresholds may have been raised in the past year as well. But if they're high volume, high value transactions, then the consumer law doesn't apply. However, there are still similar laws around misleading or deceptive conduct outside the Australian consumer laws. There's a general law of misrepresentation, which applies to pretty much any commercial transaction, regardless of size, and has very similar principles to these Australian consumer laws. So even if there is a organization you're working with that's larger, it's true that they may not have this broad consumer protection regime, but it's likely that you still got to think about things in the same way in terms of misleading or deceptive conduct. And Basma said, I find that the use of superlatives is probably misleading. Yes, potentially. I mean, there may be cases where it's okay. The thing with this stuff is, again, you can get too risk averse if you don't want to use any promotional wording, and at some point, you can really damage your business by not being willing to promote it because you're so worried about the legal risks. And so I do always come back to this table. Just keep this in mind, but ultimately, you got to work out how you're going to promote your product with an eye to these risks of misleading conduct. So now let's move on to the next topic, social media and influencer marketing. So this is a new area where a lot of organizations will be posting on social media, sometimes paying influencers or other third parties to share their content and talk about how or do a review of their product or service and talk about how amazing it is. They'll want to share or repurpose user-generated content. Sometimes they'll want to promote their brand using music of a famous artist. So we see all this stuff happening on social media, and questions arise as to what you can and can't do. Now, again, coming back to my very first slide, there's some things that may break the law, and some of these laws around misleading and deceptive conduct, and there's things that may just be a breach of the platform's terms and conditions, and they're kind of different types of law here, and this definitely applies in this case of social media and influencer marketing. So we'll just start with the kind of sponsored content stuff. So I think influencers that are posting content that's pretending to be authentic but is actually paid content potentially breaches the law we were just talking about around misleading conduct. We're not just talking here about fake reviews or misleading price comparison tables. But if somebody thinks this is a genuine, authentic experience, but they've actually been paid to act it out, you have likely deceived a customer. So I think there can be a real risk if there's no disclosure that the content is sponsored or paid for, that you're breaking a law if you're doing that. Now, this stuff has not been going on for that long. Influencer marketing has been around now for 5-10 years, but really probably grown a lot in the last 5 years. And but in the world of law, there's not that many court cases that have actually examined influencers in court, and how the Australian law is going to decide what exactly you need to write on the Instagram post. There's no accepted wording that the High Court's ruled on that says, hey, if you write the words, this is a sponsored post, everything will be okay. But if you don't say that, it's fine. We don't have that level of clarity from the legal system as to what exactly we need to say when we're doing sponsored content. Now, there's something called the AANA code, which is an advertising code that exists in Australia. I would encourage people that engage in any of this sponsored content stuff to go check out the code. They've put together some industry standards around how to disclose sponsored content. I think if organizations follow their guidelines, even though they're not written by the government or written by any of the platforms, they're just a kind of suggested model for how we disclose sponsored content. My view is if you're complying with that code, it will bring down the risk of your sponsored content being unlawful to be pretty low risk. And they suggest different wording that you can use on different platforms to disclose that the content's sponsored, whether it's a disclaimer on the post or mentioning it in the piece of content itself. They've got some good guidelines for different scenarios. But ultimately, with a lot of this stuff, what you want to be thinking about if you're designing this content is, would someone watching this know that it was paid for or not? And they kind of need to know it was paid for, otherwise you're misleading them. So you just want to make sure that's the case. And as long as you've done a pretty good job at doing that, you're generally going to be okay. The ACCC as well have issued some guidelines on this stuff. If you type in ACCC social media on Google, they've got a page covering, again, some suggested wording and ways in which people can disclose sponsored content and otherwise promote products and services on social media so as to not be misleading about them. So again, there's guidelines online. There's not a ton of case law. But for this kind of content that's sponsored, just be thinking about, will the user be aware that it was paid for, or have I tricked them into thinking it was not paid for? And if you're tricking them, that's likely to be kind of not okay. Now on to these other 2 points, using user-generated content or licensed music. So we'll talk a little more in detail about IP later, but in general, if someone else has created content, whether it's about your product or service, or maybe it's a meme or something else, and you want to use it to promote your brand on social media, you typically do need their permission. Now, some of the platforms like TikTok and Instagram, have built-in sharing features, and the way it works is, users who have signed up to the platform and post on the platform, by posting on the platform, they've kind of agreed to allow it to be shared in that platform ecosystem. So, clicking share on a post from someone else is usually okay, but there are risks, of course. If you as an organization click share on a post, and you use it to promote your product or service, but you imply that person endorses your brand, or you defame them in some way, make fun of their video or their content, even though you might not be necessarily using it in breach of the intellectual property rights, because you're allowed to as part of the platform, there are other claims they can make against you for defamation or, again, misleading conduct in the way that you're using their content. So you do still have to be careful. It's a good idea, even if you don't necessarily have to on a particular platform, to ask for permission, particularly for if you're going to use authentic review of your content and you really want to promote it, put ads behind it, and you haven't asked permission, you may want to seek permission to do so. There's no real clear case law around what's misleading, what's defamation, and what's kind of okay. So you just want to think about, if I was going to take a user review of Sprintlaw and put $50,000 of ads behind it and promote it everywhere, I'd probably want to ask the user, because it's probably going to be in the top right half of this risk matrix. If I'm going to share a story someone shared about how happy they were using Sprintlaw for 10 seconds on an Instagram story, I may still ask for permission, but I probably it would probably be lower risk, even though someone could maybe make a claim that they didn't consent to the endorsement and so on. So I think you just have to kind of use common sense. If it's higher risk, look at seeking legal advice. I'm not saying before you click share on any post you need to check with a lawyer, but I am saying if you're going to run big campaigns around user-generated content, there are these potential legal risk issues around using their content to promote your brand. Do you have the rights to do so? And, are you potentially defaming them in some way? So keep that stuff in mind when using user-generated content. And then with music, the platforms are getting a little better at this now, but the general principle is you cannot use proprietary music of any artist to promote your goods or services without their consent. You need a license to use their music. You can't use Beatles songs with your Instagram stories, unless they've approved it. Now, platforms like TikTok and I think Instagram more recently have introduced um, a library of music that they've actually gotten permission to be used within the platform from certain artists. So you can actually now use some well-known artist music with your content only if the platform will allow you to. But if you try and upload your own video with someone else's music that isn't done through that platform functionality, they can take it down, and you can potentially be liable for unauthorized use of their music. In general, for your like promotional videos for your products and services, you just want to be thinking about if you can, using royalty free or stock music, where when you buy a license to that stuff online, typically the rights that you get are rights to promote it for your business, for marketing purposes, and so on. Obviously, making sure you pay for those licenses. Sometimes there's royalty free music which can only be used for personal use, and if you start using it to promote your business, you're breaching the terms of that license. But most lawyers would suggest use stock music where you can. If you want to do something creative with non-stock music, either A, make sure you're using it in accordance with a platform's functionality that actually allows you to, or B, you're going to have to get permission from the artist. And people would probably be aware that some of the ads that you hear, where you hear famous songs in them, the artists are getting paid a lot of money. For the right to use those songs in association with those ads, and the same goes with social media. So that's kind of how the music aspect works. A couple of questions. We have one. Is there any time that social media ads can get you into a lawsuit other than the use of others' material? I think I've covered a few of those. So as you've alluded to there, of course, using others' material, the music, the user-generated content, without their permission to promote your product and service carries risks, particularly if you're using it at scale. So that's one. But beyond that, it's this sponsored content stuff. It's potentially misleading conduct that you're doing on social media. There's potential for defamation if you're putting disparaging remarks about an organization, about individuals on the platform. And there's other laws if you're disparaging competitors as well that you may breach. So yes, there's quite a few ways on social media you can get into a lawsuit, and it's worth being aware of those. We've got a question from Julie. If our customer is a well-known company, what are the legal guidelines for using customer testimonials or reviews when promoting our services? It's not sponsored or paid content. Look, it depends where the review was given. Like if they've posted a review natively on a social media platform like Instagram, which has a share feature, by using Instagram, they have to some extent consented for you to click the share button and share that. So you may not need their consent to do so. Of course, if you then turn that into a big Instagram campaign, as I discussed, you may need their permission because it becomes a bit riskier for other reasons. But clicking share on a social platform is probably low risk. Now, if they've given you a review over email and you start amplifying that on platforms, that's a little different. Again, there's theoretical legal claims for breach of copyright by using their written content of the review without their permission. Or they may not like you using their wording to promote your goods or services, and there could be claims they could make around misrepresentation there as well, because you're implying they endorsed you. So there are risks if it's done. So you take something someone said, turn it into a snippet, and post it everywhere. So again, most lawyers would suggest just ask for their permission if you can. Most customers are happy to. We do a bunch of custom review marketing on social media. In each case, we've asked for permission. Just you can get a proper document signed, but it's often fine to just get clear written permission over email, and at least you have something in writing, which would be considered an implied license under law. So I think it's good practice to ask. And again, if you're doing a big campaign, I would maybe put a bit more rigor behind it and actually get written sign-offs. Another one, if we use YouTube links to share videos from news channels on our websites, will there be any consequences? Yeah, it's a great question. It's generally okay to embed YouTube videos because, again, when people upload videos to YouTube, they're accepting the ability for people to embed their content in various places. Of course, as I said, if you embed a YouTube video and then all around it talk about how stupid the person in the YouTube video is, you could get in trouble for defamation and so on. So you don't just have a blanket right to post YouTube links and say anything you want about them or use them in any way. If you start using them to promote your products and services, there can be risk there as well. News channels in particular, depends on how you're using them, but often if you're writing informational content, there's a bunch of exceptions around copyright law for kind of news content and so on. So if you're writing a blog post that's informing people about a topic and you're providing a link to CNN News where there was a story on this thing, it's generally going to be okay. So yeah, it's not a black and white answer. I would say in those kinds of cases, it's usually fine. But as soon as you start commenting on it or potentially using it to promote your brand more explicitly, there can be risks. So again, for higher risk use cases, you might just want to get that signed off by a lawyer. How much marketing collateral can be IP protected? For example, can your brand colors be protected? That's a good question. I might leave that one there because we've got some slides on IP coming up and we'll talk a little bit about that. We've got a question, how about Google reviews as testimonials posted on social media? Yeah, again, a lot of people do that. And I'm sure a lot of brands do the Google review screenshots without permission and get away with it. I would still ask for permission because I do think there are legal risks with promoting people's reviews, particularly if the person feels like you might have misrepresented their review in the way that you've presented it, or they didn't intend for it to be used to promote your goods or services, or maybe they have a subsequently poor experience with you, but you're still out there promoting their old reviews. There can be all these risks and theoretical legal claims. So better to ask for permission. Up to you to decide where you think it sits on the risk matrix. I'm sure that a lot of people that do it, they don't get complaints from customers, but there are theoretical legal risks. So it's probably in that category of best to get permission if you can, unlikely to be business ending if you don't though. Julie said the videos from YouTube are for general public consumption, so there won't be much risk, right? I guess that if that's a follow-on question from the earlier one, just because the YouTube videos are for general public consumption doesn't mean that you can use it however you want. Like for example, if something's on YouTube but you download it, chop it up, put it on a different social platform, that's not okay and could be IP infringement and all kinds of other things. Like I said, if you post it on your blog, but you write all kinds of content around it, about the video, there can be risk associated with that. So when a user uploads a video to YouTube, they're consenting for people to watch the video on YouTube and in some cases for it to be embedded in other places. They're not consenting for people to use it in any way that they want, if that makes sense. So yeah, I do think you got to be a little careful. And Basmazaf, what if was news of a competitor's criminal arrest? Yes, potentially, but it could be risky, right? Because again, if you're out there complaining your competitors are criminals, they're subsequently found innocent, there's defamation risk for you. So yeah, again, none of this stuff is black and white. But if you presented it in a purely factual way and carefully worded the story, it would probably be low risk, but definitely not no risk. Lots of great questions here. We're getting about social stuff. I might move on in a moment and then come back to these so we don't get too tied up on it. But let me just do one more. With blogs that are based on your own knowledge and educated opinions, do you need to specify that it's your own opinion, some kind of generic disclaimer? Yeah, that's a good question. I do have a little bit of information on blogging, but I don't think I cover this question specifically, so let me just answer it. You don't need to say something is your own opinion But to the extent you present your opinion as fact in a blog post, you run the risk of it being considered misleading content, which we've already kind of talked about earlier. So it's just safer to say opinion piece or this is my opinion. Obviously, newspapers often, when they're doing an opinion piece, they put opinion in the byline. So there's not a law that says you must write that it's an opinion. It's more about this misleading conduct. Opinions presented as fact. Certainly in the law of defamation, there's many cases that talk about people wrote an opinion on a person but presented it as fact, and then successfully ended up being sued for defamation because someone reading it thought that this was a fact about the person when it was actually an opinion. So it's safer to say that. Definitely not a requirement, but I would suggest it's a good idea just to be safe, because it doesn't cost you much in terms of real estate on your blog, and it will help reduce those risks. Okay, let's continue through some more of these slides, and then I'll come back to these questions at the end. We've already answered a few questions about reviews, but just wanted to show people this screenshot from the ACCC guidelines about online reviews. A lot of startups, you hear stories of them getting people to, getting their friends to leave fake reviews, or people paying people, outsourcing people to give them 5-star reviews, etc. This is again, there's not a specific law that says you can't have fake reviews. Instead, it's under this general law of misleading conduct. But the ACCC, who's the regulator for the Australian consumer laws, has pretty black and white said if you got a fake review, it's misleading and you can be fined and penalized for it. And this is kind of the screenshot from their website. So yeah, here you go. Hotel chain pays an influencer to tweet that she loves staying at one of their resorts. However, the influencer has never actually been to the resort. The tweet's likely to be false, misleading, or deceptive. So just keep that in mind. Again, we know a lot of clients that that do it, but it's kind of not okay under the law. So you should definitely not engage in the fake review game. So let's turn to another topic, privacy law. This is something that is very relevant in a digital marketing context. A lot of what you're going to be doing when you're setting up your marketing campaigns is trying to lead to call to actions where you're collecting people's contact details, or B, potentially doing outbound forms of marketing where you're reaching out to people and attempting to promote your goods or services. So in Australia, we have the Australian Privacy Act, which covers the use of personal information. It's actually under review at the moment, and some new laws have been proposed, which may be passed later this year, and I'm expecting more laws to be passed actually in 2025, which quite specifically affect the way digital marketers can use personal information, for example, to do targeted marketing on social media, to use cookies to track behavior, and all these other sorts of things that have become quite commonplace. So what I say now is the position kind of now, but you got to watch this space, because if some of these laws come through next year, it will have a really big impact on the way we can do a lot of our targeted digital marketing. But as it stands right now, the privacy laws in Australia are actually quite relaxed in that for smaller businesses doing under 3 million in revenue, compliance with the Privacy Act is actually optional in many cases. And you have a very light regulatory burden when it comes to privacy. Now, that doesn't apply if you're collecting people's health information, or if your business is literally just like collecting information and selling it, or what the Act calls trading in personal information, or if you can collect more sensitive information. But for businesses that are just out there collecting name, phone number, and email address, you don't actually have to comply with many of the clauses in the Privacy Act. That doesn't mean you shouldn't comply with them, particularly A, because the law is likely to change next year and it may abolish this small business exemption, and B, because I think it's become common practice today for businesses to be quite transparent about what they're doing with people's information. And so it can help build trust in your brand to actually just be compliant with the privacy laws, even though you don't have to be. And C, we'll talk about the spam laws later, but they have similar requirements to the Privacy Act anyway, and they don't have a small business exemption. But all that said, for smaller businesses, the privacy requirements are, as at today, in relation to marketing, not super intense. So what you really have to do is make sure that you have a privacy policy if you want to be compliant with the Act. And then when you're collecting people's personal information, be telling them what you're going to do with it. And you see those things on submission forms. Give me your name, your email, your phone number. Do you consent to receiving marketing and promotional materials? Do you consent to me sharing your email with third parties for the potential for you to receive, offers and deals? That level of disclosure is kind of the gold standard, and the Privacy Act wants you to be that transparent. Inside your privacy policy, you'll often have details about what you're doing with people's information. When you give us your name, email, phone number, we will use it to contact you. We'll use it for marketing purposes. We'll use it for our internal records. We may share it with our suppliers. We'll share it with our employees. Here's all the stuff that we're going to do with it. If you've got questions, here's how you contact us. That's kind of what a privacy policy is. A lot of transparency around what you're doing with people's information. And then making sure you're getting that consent up front to use it for those purposes. That's the gold standard. Now, of course, many organizations, including Sprintlaw, don't have those double tick boxes on every collection form. And in Australia, it's not a requirement to do the double tick boxes, but it does limit what you can do with people's information. Now, generally, it's considered under the privacy laws that if someone's giving you their name and email to inquire about your goods and services, implicitly they're consenting for you to contact them about your goods and services, because that's why they've contacted you. So you don't necessarily need a tick box. When you fill out this form, you consent to me replying to your form. We're not that draconian. It's implied that you can contact them, and there's to some extent probably an implicit assumption. If a customer has worked with you before, that they are interested in hearing about some changes that may affect some stuff you've done for them before, or maybe any offers that you might have for similar services. So this is why many organizations don't strictly need the tick box around marketing and promotional materials. But if your organization is really going to be sending them large volumes of content, and they may not have even become a customer of yours, they just inquired with you, or they contacted you about something specific and you're promoting something completely different. These are cases where the Privacy Act is going to say, well, you're using people's personal information in a way they haven't consented to, and you're in breach of the privacy laws. So important to keep this in mind when you're collecting people's personal information. Make sure you're getting that consent, and make sure you've got that privacy policy. And those are kind of the two pillars, basic pillars of compliance with the privacy laws. Of course, if you're a small organization and you're not collecting that sensitive data, you don't strictly even need those things right now, but I would still suggest doing them for good practice, or in case your organization becomes larger, or just to prepare for the upcoming law changes. So that's a little bit on privacy. I've done another couple of webinars on privacy where I go into this in a lot more detail. So if you're interested in this topic, they're on our YouTube channel, and you can check them out. Just turning on the right, we've got the GDPR and the CCPA. People have probably heard of these two laws. The GDPR is a European/UK version of the privacy law, and the CCPA is an equivalent in California. These laws came out in the last 5 to 7 years, whereas the Australian Privacy Act has not been updated in a substantial way for, I think, something like 20 years. So they're much more recent, and they are a good blueprint for what's going to happen to the Australian Privacy Act soon. But they actually also affect Australian businesses that operate overseas. So if you have customers in the UK or Europe, or in the US, there are much more stringent privacy requirements you've got to comply with as compared to Australia. You really do need a privacy policy. You also need what's called a cookie policy. You need to have those pop-ups that people would have seen around the internet, where you land on the website and it pops up and says, we're using cookies to track you. All of that kind of stuff is not under Australian law, but under these international laws. So just thought I'd mention that. Again, I won't go into too much detail because of international laws, but we do have a lot of clients that think they need that in Australia, They think they need cookie pop-ups and cookie consents. As of today, you don't need that if you only operate in Australia. It's only if you do cross-border stuff. So, for example, Sprintlaw doesn't use a cookie pop-up in Australia, but we do use a cookie pop-up on our UK website. We may introduce a cookie pop-up soon in Australia just because it's good practice and because I think it will be required potentially in a year's time. But the more intensive requirements are international. So if you are in that category of having international customers, definitely seek some extra privacy advice because it's a bit more of a regulatory burden there. So let's now talk about the Spam Act. So the Spam Act is a different piece of law to the Privacy Act, and it applies to the email marketing that we do. A lot of people would be using email marketing platforms, HubSpot, MailChimp, Salesforce, Drip, whatever it is that you use. We use a platform called Auto, and you would be aware that on those platforms there are kind of built into the platforms these unsubscribe notifications. Now, if you just send out emails yourself without using any of these platforms, hopefully you've picked up from marketing emails that you need to include an unsubscribe option. But the basic law that's sitting behind this unsubscribe stuff that we see at the bottom of all the marketing emails is this Spam Act, which says in Australia it's unlawful to send unsolicited commercial electronic messages without someone's consent. And every email you send, or commercial electronic message as they call it, must contain A, your contact details, and B, an unsubscribe facility. We need consent to be sending these marketing emails, and we need an unsubscribe. Now, we also need consent under privacy laws. Typically when you get someone's contact details and they agree to your privacy policy, you've actually got their consent to send them those messages. So the Spam Act and the privacy policy kind of work hand in hand in that you can use the same consent for both. But as we talked about earlier, the Privacy Act actually doesn't apply to smaller businesses, but the Spam Act applies to everybody. So again, if you were thinking for a moment there as a small business, you don't need to worry about getting consents. You do need some consent to send people these marketing emails under the Spam Act. Now, do we need that tick box every time you consent to me sending you marketing and promotional emails? Well, it's definitely better, but the Spam Act does support what we call inferred consent. So even if you don't have a tick box saying, I agree to get your monthly newsletter, if someone's worked with you, you could reasonably expect they'd want to hear from you again. You can argue they have inferred consent, and the definition is fairly vague in the Spam Act, but it says can be implied, something like can be implied from the conduct of the parties that they would expect to receive or would not be surprised to receive messages of the nature which you're sending them. So it's very much a common sense test. A lot of people rely on the inferred consent to send marketing emails, but even if you're relying on inferred consent, you always need to have that unsubscribe facility, and it needs to be very easy for the customer to unsubscribe. So again, I think this is not news to most people in 2024 that these email spams that we do need to have the unsubscribe facility. I think the consent part is something people aren't as aware of. We need express or inferred consent. You can't just buy or download a mail list from the internet and just cold email tons of people. Even if you've got an unsubscribe facility, you never had consent to use their email address. So that's actually not in breach of the Spam Act, and you can be reported to ACMA, the spam regulator, and potentially fined for that stuff. So yeah, just want to caution people against doing that. But otherwise, the key message here is the unsubscribe facility. Now, there's an interesting area of law that's, again, kind of untested, where anyone that's used Meta as a marketing platform might be aware that you can actually upload people's email addresses into Meta and use it to target them and kind of follow them around the internet. So there's a question, is that breach of the Spam Act? Because you could just upload tons of email addresses, and while you're not emailing them, you're sending them these very targeted ads on social. Is that an unsolicited commercial electronic message sent without consent? Is the kind of interesting question. The answer is it's probably not right now. The Spam Act hasn't been updated in many years. It's very much seems to be about emails only. And so there's arguably a loophole here where you can use people's emails to target them on social media uh, without actually sending them emails directly, and you might not breach the Spam Act. I think some of the upcoming Privacy Act changes will kind of close that loophole, but we do get some questions about that sometimes. So yeah, it's not super clear whether that's allowed or not allowed, but I would say it's probably not a breach of the Spam Act as of today. Just an interesting thing to be aware of. Um, we've only got 8 minutes left, so what I might do is just get through the last few slides, and then I'll go through the questions that we have for people that want to stick around and hear them answered. Just to make sure we're getting through as much as we can within the hour. So we'll probably end up going maybe 10 minutes over to answer the questions. For those that asked, there will be a recording of this on YouTube later as well. Intellectual property laws. This is an area that is very much worth being aware of when doing digital marketing. We've talked a little bit about using user-generated content and music and needing consent for that on social media. So if we just broaden that discussion out a little bit further, when we are promoting our brand or publishing content, there's different types of intangible property rights at play, and we have kind of the two most common on screen that come up in a marketing context. One is trademarks and one is copyright. So trademarks refers to rights that you can get to protect your brand name, your logo, and your kind of taglines. To answer the question earlier, in some cases you can protect things like colors, although they're fairly difficult to get. But very much the logos and the kind of words or brand names are the most common forms of protection. So, for example, in the case of Sprintlaw, I'll see if I can just flick back to one of our pages with the logo on it. Yeah, we've got a trademark for the word Sprintlaw, and we have a trademark for this little S shape. And I think we also have a trademark for business legals made simple, which is one of our tag phrases. We've just, I mentioned earlier, launched this new AI thing we're calling Tailor AI. So we're registering a trademark for that at the moment. So these are the kinds of things you can protect. Now, once you protect those things with a trademark, your logo, your name, you have the exclusive right to use your name or logo in association or to promote goods or services in the country you're registered and in the industry that you're registered. So Sprintlaw only Sprintlaw can use Sprintlaw in the legal industry in Australia to promote legal services. If another legal company started saying, we have Sprintlaw, our new division that does law really fast, they would be breaching our trademark. If they used language, even if it's not identical but similar, Sprint Legal or Sprint Lawyers or our Lawyers Sprint or our Sprint team in the legal industry to promote goods or services, they may be infringing our trademark. If, and this is more crucial in a digital marketing context, someone takes our logo, slaps it on their website and says, this is a Sprintlaw endorsed website, they are potentially infringing our trademark. Now, if a news organization talks about us in a descriptive way, or we get mentioned in someone's blog post, there's a new wave of law firms coming up in Australia, including Sprintlaw. That's okay because that's not being used to promote goods or services. Mentioning a brand name in passing is fine, but when you start using it and slapping it on goods or services to promote them, that's when you're running the risk of trademark infringement. So something to be aware of. You all will hopefully have brands for your business. First of all, you want to make sure you've actually registered them, so you have the registered trademark and exclusive rights to use that brand. And second of all, you want to watch your brand name usage in marketing. Make sure that anyone that's using it has your permission to do so as to not dilute your brand. And B, if you're using other people's trademarks, trusted by, or, our clients XYZ love us, and you're putting their logos or their brand on different pages on your site, you absolutely have to get their permission, or it's pretty much black and white trademark infringement. So So keep that in mind. And for those that go onto our homepage, for example, we've got a logo bar with, I think, 30 clients we've worked with. We contacted every single one of them and got permission to use it. Otherwise, we wouldn't be able to use their logos to promote Sprintlaw. And same when you do customer testimonials, if you want to be using their logos and various sorts of things, you just need to make sure that you're getting their permission. So that's how trademarks work. Copyright refers to any original work recorded in material form, and what that kind of legal definition means in a business context is things like written content, blog posts, designs, images, photography, music, any of that stuff that's original may attract copyright protection. And copyright's different to trademarks. You don't actually go register it. It's automatically owned by the author. So if a photographer takes a photo, they will own the copyright in that photo the second they kind of hit click and it becomes a photo. If a person writes a blog post, assuming it's original, the second they put the full stop at the end of the blog post, they own the copyright in that blog post. And what you have to be careful of course, is A, making sure you own all the copyright and what you're publishing, but B, making sure if you're using other people's images, you're using other people's music, you're using other people's blog content and republishing it and posting it to promote your brand, again, you're not engaging in copyright infringement. And unless you're using, stock footage, stock photos, stock music, chances are someone owns it. And now that there's good Google reverse image searches, there's a pretty good chance they're going to kind of come to you and say, hey, I want to be paid for you copying my content. Plagiarism doesn't really have a legal concept, but this concept of copyright infringement or IP infringement certainly does, and it's something we see come up a lot for brands, blogging or posting stuff on social media. They'll be wanting to use other people's content. They haven't got their permission to do so, and they therefore run the risk of copyright or IP infringement. So keep that in mind when you're producing content. Always get permission if you're using someone's works or use stock stuff. On Sprintlaw's blog, for example, we exclusively for all of our images use stock imagery. We don't just find stuff off Google that could be owned by someone, we use that, or we use photos of our own team that we have permission to use. And of course, when we pay a photographer to take photos for our team, we'll make sure they transfer the copyright or license the copyright back to us to be able to use their photos to promote our brand. So that's kind of how it plays out in practice. I'll just cover off our final slide on competitions and promotions, and then I will dive into the many great questions we seem to have. Just quickly, for those that want to run competitions on social media or otherwise online, this is something we see happen quite as a common way to promote something in a digital marketing context. Be aware that there are actually laws around running competitions. The law puts competitions into two categories. One is called a game of chance, and one is called a game of skill. Now, if your competition is, an industry award where people are judged on their merits and someone wins an award and has to pay money to enter, that's generally fairly low legal burden because there's some skill merit involved in selecting a winner. If someone has to, complete a challenge to win a prize, again, if it's not based on chance, it's fairly low legal requirements. If someone is being judged on their creativity, again, there's some skill involved who did the best design for XYZ. But if you've got a game of chance, go into the draw to win X, win a free whatever for our product if you do XYZ, and it's just a lottery where a winner will be picked at random. That's called a game of chance, and there are laws around that. First of all, you need to really have terms and conditions, really for both sets of competitions, whether they're skill or chance, to make it clear which of it is and how it works and what the criteria is to prove that it isn't a game of chance, a game of skill, if that's what it is. And B, if you're doing a game of chance, depending on what state you're in, you need to get a permit. In New South Wales and the ACT, they're pretty much always required. In Victoria and Queensland, I think it's based on the size of your prize, and but Western Australia and Tasmania, again, similar requirements. And South Australia, I think, has the most strict requirements around what's required. So keep that in mind as well. We do see people running competitions and breaching these laws because they're not aware of them. So I just wanted to make you aware. If you're thinking of running a competition, probably a good idea to reach out to a lawyer and make sure you've got the necessary permits. Okay, so that was all the legal content. We've got 14 questions I'm going to just run through for those that want to stick around. For those that are dropping off now, thank you so much for attending. We do these every month on various topics. Would love to hear feedback or any topics people want to learn more about, and we can build it into the schedule. Otherwise, thank you so much for attending, and I hope you found this useful. So let me dive into these great questions that we have. First, Jeanette's asked, what if you use YouTube videos for educational purposes? Yes, there is actually an exception to the Copyright Act for education, which does allow, for example, teachers and universities to use videos in lectures without it being necessarily IP infringement. So that's okay. But of course, if the educational purposes, there's a very clear definition of, well, when I say very clear, it's a very legal definition of what constitutes education in the Copyright Act, and it very much is intended for tertiary institutions, secondary institutions. So if you're running like a course, private course, that's kind of your business model to make money off the course, you may just have to double check whether exactly what you're doing meets that requirement, and if not, you could, potentially be liable for IP fees to the creator of that content that you're trying to monetize. So we actually do give legal advice on that question reasonably often to online course creators. Can they use the content? Can they not? And again, we often give them a risk-based answer and tell them how to structure the course so they can reduce the risk of it being infringement. So yeah, not a black and white question, but there is a potential exception for education purposes, which is how universities and schools are able to kind of use it without worrying too much. Julia's asked, what about embedding other website links onto a website like ASIC company search or spot a scam so customers can search and do their fact check? Look, generally, if you look at the terms and conditions of government tools, they are pretty happy for you to do stuff like that. Again, it's not a bad idea to contact them and just ask permission. It's not going to take you too long, and they'll let you know if they've got any guidelines around how you do it. ASICS has an API for their company search, which means like a lot of organizations just plug in the company search into their like sign up forms and those sorts of things. So it's certainly common practice. But if you want to do that, ASIC does require you to agree to terms and conditions before you put it on your website. So again, it's usually fine. Technically, you do need their permission to do it. So I just ask them, but I don't think there'll be a big hurdle in getting that permission for those kinds of purposes. And sorry, yeah, you talked about embedding. Of course, providing a hyperlink to their website rather than embedding it is very likely to be okay, unless you're misrepresenting what that link is. Sending someone to another website via a link is usually fine because they can then check out that website themselves. Basmas asks, is there a legal definition of what is a fact? I assume that's in relation to some of the stuff I said a little earlier about the difference between opinion and fact. No, there isn't, and it's obviously quite a political topic right now. And I think some emerging laws are coming out on how we define fact and not fact. But I think what's going to happen if you're promoting content that's misleading as opposed to factual, a lawyer can never tell you yes or no that's a fact versus not a fact. But courts clearly have processes for determining things, and in these examples I gave earlier, they looked at scientific evidence to work out whether this was a fact or not, and there was a point of debate whether it was a fact or not. Eurofin was arguing this is a fact, and that's why they went to court, and Panadol was saying no, it's not, and it could have gone either way because it's not a clear definition, but based on scientific evidence, clearly that held sway in what was factual. So that's kind of how you might think about it. And the more you can justify something, the more likely it is to not be considered misleading and therefore to be considered factual. So yes, that's an answer to that one. Someone's asked if it's someone deliberately writes a review on a platform to tarnish our brand, what can we do immediately? So not a bad idea to contact a lawyer if you need to, but look, it's difficult. There's defamation that you can make, claims you can make against people for writing untrue reviews. Although defamation, I think, only protects individuals and is not really a claim you can make for a business, but you can make negligent misstatement claims or misleading and deceptive conduct claims. So there are legal claims you can make against someone that writes false reviews. Of course, we talked a lot about the false review laws. So if a competitor comes along and makes up that they use your service and pretends that it was terrible, the question becomes, what can I do about that? So yes, they can be legally liable. Now, are you going to go and sue somebody for leaving one bad review somewhere? Probably not. So you can threaten them if it's false with legal action. You can report them to the platform, like Glassdoor or Google Reviews, and flag it as a false review. Glassdoor, for example, has a process where you provide evidence as to why it's false, and they consider it, and they may remove it. You can contact the individual if they are a customer. If they've got a good reason for having left the review, maybe you can try and solve it with customer service rather than legal means. Google, in general, on Google Reviews, won't remove a bad review if just because you don't like it. That's one of the points of their review feature. And again, a defense to a lot of these defamation type legal actions is truth. So if it's or substantial truth. So really, if you want to take any legal avenue, you have to establish that it's a false review, and you probably have to do the same if you want to convince a platform to take it down. So if it's a true review, responding to it in customer service is probably your best bet. But if it's a false review, I would consider those avenues of reporting it to the platform or contacting the customer. And if it's really bad, considering a legal letter. Another question, is that even if a list is a directory specifically for employment and that is your purpose for contact? I think that was left in relation to something I was saying 20 minutes ago, so I'm not sure as a context. So Basma, you may have to give me a bit more context on that one. Next one, what about platforms that are GDPR compliant and sell company contract data? Can we email them if the supplier has met GDPR rules? Potentially, yes, you could. If they have gotten customer data in a way where the customer has explicitly agreed that it could be sold or provided to a third party that may contact them, then that's okay. But you just want to be completely sure that that's the case, because you may be liable as the organization if they're not compliant. It's not just that, maybe you could cross-claim from them some amount of money, but you could be fined directly by a regulator if you contact people without their consent. Even if you reasonably thought they'd given consent, that's not going to be a clear defense to that. So the answer is yes, but just be careful and maybe ask some more questions to verify that they've actually met those rules. You'll also need to have your own kind of processes for unsubscribes and all the other things I talked about if you're sending them marketing emails. Julie's asked, what additional security measures can we implement to build trust and combat scams when collecting sensitive information, such as photocopies of IDs, especially considering we already utilize these servers which offer encryption two-factor authentication? Look, that's probably more of an IT cybersecurity question than a legal question. I think it sounds like you've already got some rigor there. The Privacy Act from a legal perspective just is more about consent requirements and information requirements rather than security. The law just wants you to tell these people when you're collecting the information, what you're doing with it, where you're storing it, how they can ask you questions about it. So from a legal standpoint, that's one of the key things to do. There's also legal reasons to make sure you've got good security measures so you're not being negligent. And so you definitely want to use all your efforts to enforce security. But in terms of what you can do beyond what you've already done, I think you might want to engage a cybersecurity agency for some advice on that, or do some digging with IT professionals. Yeah, a bit outside the scope of my legal knowledge, I would say. A question about a medical group. On the group's website, we have logos of memberships. They have, is that okay? Not all the doctors are members. Most are, but not all. Good question. Look, you technically need the permission of your memberships bodies, AMA, GESA, to use their logos. I would imagine that if you read their terms and conditions, they've probably already given you permission, because that's the whole point of the memberships. But if you haven't checked that, to just dot the I's and cross the T's, you should just check they're okay with that. But yeah, again, I wouldn't be surprised if they are okay with that. Then in terms of not all the doctors are members, most are, but not all. Well, that's a bit risky, because it depends on how you do it. If you said on the website, everybody is a member of this association, and that's not true, then that I think would be considered misleading. If you have their logos presented in a way that implies everybody's a member, it would kind of depend on what content you have around those logos. If you can say, like, many of our doctors are members of these, obviously that's okay. And if you say, we as a group maintain membership to this, maybe that's okay. Yeah, so it depends on the specifics. The test is it misleading? And so those are some different ways you might think about it. And again, if you're getting really nervous, you can get a lawyer to help you write up the exact wording on that topic. But that's how you would think about it. Is a reasonable person going to look at this and kind of know that it's not 100% of people, or could they really think that and be misled? Jeanette's asked, what about AI generated images based on my prompt? I assume that's in relation to stock imagery. I mean, look, there's probably a 2-hour webinar I could do just on that topic. I have actually written a blog post, I think, on AI generated images, so you can have a look at that on our website. Short answer is the law is quite unclear right now on using AI generated images. On balance, on most platforms, it's probably low risk of being infringement to actually use an AI generated image. The platform's unlikely to come after you. But medium term, we're going to probably see the law change a bunch around this area. There's been a couple of cases where people did AI generated images. They looked a lot like a famous cartoonist, and that cartoonist started suing people. So there's a case pending in New York challenging what I said about it being generally okay. So it's just an unknown area of law, but it's being done a lot, and there haven't been that many court claims yet. So I don't really know where it sits on my risk matrix right now. But I think if you're using it with a small scale audience, it's probably pretty low risk. But if you're going to do a big campaign with them, just be aware that it's a pretty unsettled area of law. With a trademark name and logo, does the owner need to put the TM symbol? No, the owner does not need to put the TM symbol. Now, there's actually an R symbol and a TM symbol. The R symbol, you have to actually have a registration to put the R symbol. The TM you can do while it's still pending, but you can't use the R unless you actually have the R. You don't have to use either of them, but it's considered good practice. First of all, it just makes your brand look a bit better. And second of all, it puts people on notice that, if they try and use this thing, they're going to get into some trouble. So often if there's a little R attached to your logo, someone tries to put it on their website, they're going to contact you before they do it. And so it's a good practical thing to do, but it's not a requirement that you actually use it. And again, we don't use it on our website at all at the moment because it didn't really fit the design, but we could if we wanted to. What about reports? If the client presents a report as hers, although he paid for report writing, is that copyright breach? He does not mention in any way the author. So yeah, I'm not 100% clear on the context for this. I mean, if an organization pays somebody to publish a report and then like ghostwrite something. Oh, I see what you mean. So you pay a ghostwriter and you present it as you as the author. I don't know that would be a copyright breach. If you have a contract with the ghostwriter and the ghostwriter agrees to give you the rights to republish it, that's usually okay. They would also have to give you the rights to attribute it as yours. Someone could argue that you're committing misleading conduct by putting your name on it when you didn't actually write it, although ghostwriting is a pretty common practice, and so on balance, it's probably okay to be ghostwritten as long as you've got something in writing, basically that you've got the full rights to present the report as your own. Only a few questions left, although we're quite over time, so I might just do one more and wrap up. So Basma's asked, what about piggybacking by putting your hashtags when sharing other social media posts? I think some of what I said earlier on social media applies to the hashtag thing. If you have the rights to share the post, you're using it in a way, maybe you're just sharing a post on the platform on your own social account. Using the share feature, then you may not need specific permission. And then putting your hashtags on it, I don't think is going to make a very big difference. Of course, if you're then sharing someone's content, putting hashtags on it, and then running a big campaign off the back of it, pretending that they endorse your brand, then it's going to be an issue. So I think it's less about the hashtags and more about the use, if that makes sense. And I doubt that the use of hashtags alone would move the needle much either way. Thanks so much, everyone, for sticking around and for the great questions. Again, if anyone else has questions, we're very happy to take them as part of a free consult. Otherwise, I'll see you all at our next webinar, if not before. Have a great day.